So January 20th, I would like for us to reconvene for status. And then officially, it will be a 4/16, 4/27 sounding in trial. I think that's pretty much all we can accommodate at this point.
All right, 4/27, that is April 27th, obviously. The judge setting the court date, the trial date for Courtney Clenney. Key rulings on Thursday's hearing, though, could tip the scales for her defense. Clenney appeared in court for two pressing issues, basically. Her attorneys were hoping to dismiss some privileged material that they believed that was related to the investigation. They don't want it coming into the trial. And a request for bond. Both were addressed by the judge, Judge Wolfson, before setting that trial date. Take a listen.
First and foremost, as to the defendant's motion to dismiss information based on repeated government misconduct and obstruction of evidence pursuant to Brady and Youngblood, the court is respectfully denying that without an evidentiary hearing. But as far as the defendant's second amended motion for reconsideration of bond, the court does not believe there has been a subsequent event or new information that would materially alter the prior wishes of Judge Cruz pursuant to 907-0415K and Florida Rule of Criminal Procedure 3.132M, and that motion is also respectfully denied.
All right, so Courtney Clenney lost to both of those motions, and she'll be in jail for the holidays, but her trial's coming up. So let's get down to business here. Frank Prieto is with us, Courtney Clenney's attorney. Your reaction to the judge's rulings yesterday, lost to both. Are you expecting that, or what's your take?
Good morning, Ted. Yeah, like you said in the outset, the good news is we have a trial date certain. The bad news is we did not prevail on either of the motions. Look, it's expected. A lot of times defense lawyers need to file motions to preserve the record on appeal if the client were to be convicted. We don't believe that's going to happen. We believe we'll show that Courtney acted in self-defense to save her life. But we have to file motions on the defense side to preserve the record. But just to clarify, one of the motion to dismiss was not based on the privileged materials. The motion to dismiss was based on newly discovered evidence that a police officer told a building employee who was the first person to arrive before the police. That gentleman was taking videos and photos of the crime scene. And a police officer, according to this person's sworn testimony in the civil case, told him to delete everything. In fact, stood over him and made him delete all these photographs which would have shown the pristine crime scene. So that was the basis of the motion to dismiss, on top of obviously the prior misconduct of the government, reading our privileged emails and texts. So, but again, we did not expect to prevail on that. The motion was difficult. The motion for bond, difficult to prevail on because the prior judge's ruling. So Judge Wolfson gave us a great hearing and was very thoughtful about taking the evidence, but we did not prevail. Very difficult situation to get a bond at this point.
Will you be able to present that at trial, the story of the police officer allegedly telling the employee to delete everything at the crime scene?
We should be. That may be a discretionary call on the part of Judge Wolfson. We will be asking the court to basically instruct the jury after we elicit that testimony. The judge in their jury instructions, we're going to ask for an instruction that says we're entitled to a negative inference from that, meaning that the evidence could have been potentially useful to us, and instruct the jury as such that they can make a negative inference from the destruction of that evidence.
The videos that are out there that show your client and Mr. Obumseli quarreling, fighting. Sometimes it's physical. Sometimes it's just, yelling, all of that. Will the jury see all of that? Or are you trying to restrict some of it? What's the defense strategy in terms of what you want the jury to see and what you don't?
Right. Well, the videos, so the media and actually the state attorney's office at their initial press conference, right, the infamous elevator video is actually helpful to us. What people don't see is, and I know you have the elevator video coming up.
Cue it up. Yeah.
Prior to this, when Miss Clenney gets on the elevator by herself and goes down to the lobby, because this is when she got back onto the elevator from the lobby to go upstairs, she's actually, when she moves out of the elevator, you see there's a puddle of blood. She was injured when she got onto that elevator, which is why she was so adamant to not have him go back up, because he had the only key fob. And with that key fob, he has direct access to his apartment, and she had actually gone down to call the police. So when we show the actual beginning of this video, not just the snippet when she gets back on in the lobby, the jury's going to understand she was injured, went downstairs to get help, and then decided not to call the police when he showed up in the lobby. So there's a lot of backstory that the jury's going to hear that is not out there. And those recordings that have been played as well, those are 100% inadmissible. And in fact, Judge Cruz should not have even listened to those. The surreptitious recordings, I think Julie Grant had also asked about this many moons ago. They're inadmissible. Florida's a two-party state. You cannot surreptitiously record anybody. It is per se not admissible evidence. So that will be thrown out.
Will Courtney have to take the stand? If this is a self-defense case, 9 times out of 10, your defendant is up there telling the jury their fear and their story. Is there any other way to get that across to the jury without her?
There is, if her statement to the police is deemed admissible, there's going to be argument about that. The state has taken the position that it's self-serving hearsay, which would not be admissible, versus a quote-unquote confession, which is admissible. So there's going to be litigation about that. But Ted, you're absolutely right. In a self-defense case, most lawyers will tell you there's no other, unless there's some type of third-party witness, independent witness, which we do not have here. There were 2 people in that apartment. But Ms. Clenney will take the stand more likely than not and explain, how she was battered mentally and physically, and that the actions she took that night were to save her life. And that, in combination with the world's most renowned battered spouse expert, Dr. Lenore Walker, who's going to testify that Courtney checks all the boxes.
Frank, we got to go.
Spouse.
Thank you, sir. April 27th, trial date.